enter a plea of guilty or nolo. You may wish to enter a plea of not guilty, and while you prepare for trial, you can also look up that information.
All right, folks, welcome back to the channel, and buckle up, because today's case is an absolute circus. We're diving into a sovereign citizen showdown where the defendant shows up with what he claims is his very own attorney general, who looks like he just stepped out of a Renaissance fair armed with both a gun and a sword. Yes, really, you're about to see it for yourself. We've actually got to separate court appearances to break down, each one more chaotic than the last. So we're going to walk through them step by step. Grab a drink, settle in, and let's kick things off with appearance number 1, where the confusion begins long before the weapons enter the
All right, DeMarcus Contrell Brown.
Your Honor, we were representing him, but we are going to be submitting a withdrawal to you. You should have it shortly.
All right, Mr. Brown, are you represented by somebody else?
Yeah. For the record, I am DeMarcus Bay, the implied surety for DeMarcus Contrell Brown. And I would like to file a motion in the court for additional 30 days for me to seek counsel.
Okay, so Mr. Bay,
Yes.
aka Marcus Contrell Brown, so you're seeking a continuance to get new counsel?
Yes.
Okay, do you have someone in mind, sir?
I not right now. I'm seeking counsel.
I'm not buying this story for a second. As you're about to see, our guy has definitely already picked out his so-called legal representative, and let's just say this counsel looks like he was recruited from the after-party of a discount cosplay convention. The whole act falls apart the moment you realize he had this character waiting in the wings the entire time, so while he's in court pretending he needs more time to find an attorney. We already know the plot twist. He's brought someone who makes the average Facebook law expert look like a Supreme Court clerk.
Okay, so here's the thing. I'm going to give you a continuance for 30 days, or I'm sorry, until January 5th. But by that time, you need to have counsel on board when they come back so that they can talk to the state to determine if there's anything they can work out on your case, or if they need to get all of the information necessary for a trial, if that's what you choose to do. So by January 5th, I will expect that you will have counsel.
Well, I have paperwork on the docket that haven't been rebutted. I have affidavits of truth that haven't been rebutted.
Okay, sir, we don't do affidavits. People have to appear in person because there's a confrontation clause in the United States Constitution that says witnesses, you have the right to confront witnesses in person. So we don't do affidavits, okay? If you have witnesses that are going to present testimony or evidence on your behalf, then you have to have them come to court and be sworn in and testify at that time, okay? So we're not doing any dismissing and all of that stuff. No, sir. When you get your counsel, they'll be able to discuss it with the state, and then y'all can present whatever to the court.
And the accusing deputy must be present too, right?
And here's where the judge tries, once again, to walk him through basic courtroom procedure. She calmly explains that the deputy doesn't magically appear just because he demands it. You actually have to subpoena the witness like every other adult in the justice system, but of course, this is news to our sovereign citizen, who seems convinced the state is required to hand-deliver every person he wants to question. The judge spells it out plainly. If he wants someone at trial, he has to make it happen, not the prosecutor, not the court, and definitely not whatever imaginary legal department he thinks he's running actually. This clarity sails right over his head. But credit to the judge for at least...
Okay.
So the people always say that, but here's the thing. The state gets to choose whatever witnesses they wish to bring, just like your side gets to choose whatever witnesses you wish to bring. You can't rely on them to bring the person that you want. So if you want to subpoena someone to appear for trial, then you need to subpoena them. You cannot rely on the state to bring your witness. Okay?
Okay. I got you.
All right. Anything else?
And jurisdiction can be challenged at any time, right?
No, sir. Jurisdiction rests with this court because this is where the locus of the incident is.
Well,
Mr. Bay, let me just explain something to you. Mr. Bay, listen to me.
Okay.
I went to school for 3 years for this. That's full time. If I had gone part time, it would have been 4 or 5 years. And I have been working since, oh Lord, I ain't gonna give my age, but I've been a lawyer and a judge for quite some time. I've been a judge for 10 years as of this year. A lot of times people come before me because they've learned stuff from other people, or they've gone online, or they've read it themselves. But I tell you, it doesn't work the way you think it works. And so there's a set of statutes, cases, procedures, all of those things that we have to learn. In fact, let me show you something.
Well, how do you have?
Wait. You see this book right here?
Oh boy, the second she brings out an actual law book, you can practically see his brain buffering. Nothing throws a sovereign citizen off balance faster than real. Physical legal material is the part where their YouTube law education starts to crumble. Because the judge isn't quoting memes or magic phrases, she's holding the very stuff that courts actually use. And the best part, she's only showing one book, and he already looks like he's about to tap out of the match if this chapter alone rattles him. Wait until he finds out judges keep entire shelves of the.
This is just this year's edition of all the stuff that I have to be able to find to figure out what's going on in your case. This is just this year's edition. And I got a book like this that includes evidence and procedure. I got a whole wall of books. So when you come in here challenging jurisdiction and all of this stuff people have taught you, it's
I got
not
books. Can I show you my Black Law Dictionary?
No, sir. Because Black's Law, that's a dictionary. That's not the full case. You know, you come in with all of these ideas about how you think the law works, but every lawyer in here has done at least 3 years of law school and trainings, trials, all of those things. So you're not going to change the way we do things. So the best thing to do is to get an attorney who can talk to the state about your case, and then we can get this resolved. Your case is pretty simple. You got traffic offenses.
You've got to love it. The judge reminds him this whole case is just traffic violations. Nothing earth-shattering. And yet somehow, sovereign citizens turn the simplest, cheapest requirements in society into financial disasters, and mini epics of self-inflicted chaos. Blows my mind every time. Instead of paying a small yearly fee like everyone else, they'll rack up fines, court dates, bench warrants, and sometimes even jail time, all while acting like they're uncovering some hidden constitutional conspiracy. An Olympic-level effort to avoid the most basic adult responsibilities. And in the end, they spend more time fighting the system than it would take just to follow the rules. But hey, nobody ever nominated a sovereign citizen for the Most Practical Thinker Award. The harder they struggle, the deeper the hole gets.
Well, I still want you to prove on the record that you have subject matter jurisdiction, personal jurisdiction.
I'm not proving anything on the record, sir. I wear the robe. They put me in this position. I've been here 10 years. If I didn't have subject matter jurisdiction, I wouldn't be here.
So you say it's not a difference between public and private for the record. There's no difference.
Sir,
get an attorney. Okay, all right. January 5th.
Yes, sir.
Okay.
And Mr. Bay/Brown, you've indicated that you wish to have an attorney, so I'm going to rely on the fact that you're going to have an attorney. Don't come back here with the same stuff, and I already told you it's not going to work.
So you're telling me United States codes don't work?
No, I'm telling you, you don't know them.
First of all, right here.
The United States codes don't work in Georgia because Georgia has its own code, OCGA.
So the meaning of driver is different in Georgia.
Yes, sir.
But according to 49.
Mr. Bay, I'm not doing this with you. Get an attorney.
Okay.
Thank you, sir. You're free to go. We'll see you on January 5th at 11 a.m.
All right, so that's the end of his first appearance. Now let's get to the spicy bits, where he brings on his attorney, who also happens to be an attorney general. And oh yeah, his lawyer also thought it was a good idea to bring a gun and sword into the Zoom court hearing. Let's call this segment How a Not Attorney Fucked His Not Client's Case Up.
So, DeMarcus Contrell Brown.
I have interest in that matter. Is the defendant ever free to go?
Is the who, what?
Is the defendant in error free to go?
No.
Well, let the record show the defendant in error is ordered to state and participate.
Well, he tries to put on his legal scholar voice and declares that the defendant in error is ordered to stay, but honestly, the only thing he's proving is his commitment to sounding like a malfunctioning courtroom chatbot. And if we're being real, the judge doesn't even need to respond, because the moment he finishes, it's painfully clear he's not exactly the brightest bulb in the judicial chandelier. His is peak sovereign citizen theater. Invent a title, misuse some legal terms, and hope everyone is too stunned to question it. Spoiler, they're not. The judge has seen every version of this song and dance, and his performance isn't even in the top 10 at credit where it's due. He delivers it with absolute confidence, even though the rest of us are watching him trip over his own script in real time.
Okay, who is the defendant in error? That's a new one for me.
The all cap name is trust that I am a beneficiary of. My name is not spelled in all capital letters. I have a court order decree saying that.
Okay, Mr. Bay. Mr. Bay, do you have an attorney representing you, sir?
Attorney General, my Attorney General is online. You may speak to me, sir.
Is the Attorney General, Mr. Bay, hold on, let me ask my question before you tell me something crazy. Is the Attorney General a member of the State Bar of Georgia?
I'm a non-state actor. I'm a foreign national. Matter of fact, I filed
Sir, Mr. Bay.
your oath of office.
Mr. Bay, I don't care if you were Alexander Putin, the premier of Russia. If you are in Georgia and you're represented by an attorney, that attorney would have to be a member of the State Bar of Georgia. Foreign national or not. Just as if you went to another country and you had an attorney represent you, that attorney would have to meet the requirements of that country and of that state. Okay, Mr. Attorney, Mr. Bay, hush. Mr. Attorney General.
I'm trying to set a record.
Mr. Bay, Mr. Attorney General, are you a member of the State Bar of Georgia? You want to unmute for me?
Speak, bro. Get off.
I've got to say, putting your fate in the hands of someone who looks like the love child of a bargain bin pirate and an off-duty reality TV bounty hunter is a bold legal strategy. Not a smart one, but definitely bold. And since your attorney has already jumped into the conversation uninvited, we might as well hear whatever cinematic nonsense he's about to unload to this point. It's hard to imagine him making your situation any worse than you've already managed on your own. So maybe letting him talk is just a formality. Still, if you're gambling your freedom on cosplay courtroom energy, you might want to brace yourself, because the judge looks about 2 seconds away from deciding she's had enough of this community theater legal team next.
What's going on is he's a member of a foreign state corporation, basically doing business in Georgia. So
Okay,
basically,
sir, that's not what I asked you. No, sir.
I get what you're saying,
sir.
man.
No, and I get what you're saying, but we're not doing
I
that
know,
because that's not how we operate. Those are not the laws under which I am required to conduct court. So we either gonna do it my way or we're gonna put you
We
on
understand
the
the rules of
calendar.
the court. We understand the rules of the court. I got you.
Okay, are you a member of the State Bar of Georgia?
No, I'm not a member of the bar of Georgia.
Okay,
What I'm
then
trying to
no,
realize
then
he's
as
doing business a certain way
he
in
can
Georgia,
represent
and that
himself.
you need to take consideration on that matter on how he's doing business in Georgia.
He can represent himself, or he can be represented by a member of the State Bar of Georgia. But he cannot have you represent him or purport to represent him. Okay, that's not going to work. All right. So, Mr. Bay, do you wish to choose someone who is a member of the State Bar of Georgia to represent you, or do you wish to represent yourself?
I invoke my right to remain silent as the beneficiary of Demarcus Cottrell Brown estate.
Okay, sir. So, sir, you're invoking your right to remain silent, which means that you do not wish to enter a plea that
I plead to be released.
That would resolve your case today. As such, the court is going to enter a plea of not guilty for you.
Jet, you cannot practice law from the bench.
I mean, sure, technically the judge could just enter a guilty plea for him, but that would be the legal equivalent of skipping straight to the game over screen. The whole justice system is built on the idea that the state carries the burden, not the defendant, which is why the automatic starting point is always not guilty. It's only when the defendant voluntarily changes his plea or the prosecution presents solid evidence that a conviction can happen. Until then, the law assumes innocence, whether the defendant understands that or not. Oh, honestly, she's doing him a favor by taking the safest route here, even if he's too wrapped up in sovereign citizen theatrics to realize he just dodged a much worse outcome.
Violation 28 U.S.C. 454. Judge practicing law from the bench.
And put you on a trial court, on a trial calendar so that your case may be heard at trial.
Object.
All right, sir. Thank you. You'll get notice in the mail. If anything changes about your address, then you can go ahead and let us know by coming in.
I demand evidence hearing.
You will have that at the time of the trial,
evidence
sir.
hearing.
You're not going to have an evidence hearing today because that's not what we're here for. This is
you are dishonorable. I got your oath, Tammy Long. Hey.
So, Mr. Bay, I'm going to enter a plea of not guilty on your behalf. You'll have a trial at which time you can have an evidence hearing. You'll get notice in the mail.
You're in violation of Article 6, Section 2 of the Constitution.
Your notice in the mail, then you can appear for hearing with whatever evidence that you wish to present. Although you are not required to present any evidence or testimony because the state has the burden of proving the case against you. Thank you, Mr. Brown. You're free to go at this time. All right, Kevin Jermaine Burrows.
Something tells me the judge isn't losing sleep over that last objection, mostly because it came from someone who's clearly operating with fewer functioning brain cells than legal arguments. She's already moved on, and honestly, who can blame her? Anyway, that wraps up today's courtroom roller coaster. I'll be keeping tabs on his upcoming hearings, and the moment anything wild or ridiculous pops up, which let's be honest, it will, I'll bring it straight to the channel. If you enjoyed the breakdown, hit that like button, and if it wasn't your thing, the dislike button works too. Just make sure you drop a comment with your thoughts, predictions, or favorite facepalm moments from this case. And of course, don't forget to subscribe and turn on notifications so you don't miss the next round of sovereign citizen chaos.